Today is Monday, June 22nd, 2020. This is the Standing Committee on Health and Social Development. We are here in part one, which would be the morning, and that'll run till 12 o'clock. And we're here to discuss the considerations of motion number 75, which is looking at Bill 37 that was referred to this committee from the Legislative Assembly, an act to amend the Emergency Measures Act to the Standing Committee. Welcome. I'll just go through some housekeeping items here today. As you can see, we have a full agenda today. I'd like to give a few reminders before we begin. Please wait to be recognized by the chair before beginning your remarks. This will help the audiovisual staff with capturing your remarks. As discussed last week's meetings, we have agreed to the following limits in regards to the presentation by departments. Each department will have a 10-minute opening statement. If they have comments past the 10-minute mark, we will try to give them some flexibility. Followed by 25 minutes of questions by members of the committee, 5 minutes each. There will be a 10-minute buffer at the end of the meeting. If there are visiting members, which there are not this morning thus far, who would like to participate for any additional questions by committee members. We'll be taking a 10 to 15-minute recess between presenters in order to clear the commons in the chamber, and especially with COVID, we'll clean everything down. Again, a reminder to please speak through the chair. At this time, can I have an adoption of agenda by one of the members? Hannah Bell. And just for people watching at home, we have in attendance Trish Altez, Hannah Bell, Jamie Fox, Brad Trivers, and my name is Gordon McNeely, and I am the chair. So at this time, I will pass it over to our guests to introduce themselves for the record and then begin their 10-minute presentation as they see fit. Thank you.
So I'm Brian Matson. I'm the Deputy Minister of Agriculture and Land.
And I'm Bobby Cameron, Director of the Strategic Policy and Evaluation Division with the Department of Agriculture and Land.
Perfect. Thank you.
Okay. Thank you.
Great.
I'd like to thank you for the invitation to present to the committee today. We are here to present information on the acts that fall under the department's area of responsibility, how the COVID pandemic impacted the operations of the Department of Agriculture and Land, exclusively in relation to the impact of legislation barriers on the department, and to identify sections of acts which could be researched further to determine if amendments are needed to accommodate responding to a state of emergency. In your letter, Chair, to our Minister, you asked that we provide in writing a letter back prior to our meeting today. However, having worked over the weekend, we haven't had a chance to review that with the Minister, so we will do that as soon as we can.
Perfect. Great.
Okay. So now I'll pass it over to Bobby to go through the presentation.
Great. Thank you. So the Department of Agriculture and Land is responsible for 24 acts. This includes the Agricultural Insurance Act, the Agricultural Product Standards Act, the Agrologists Act, the Amusement Devices Act, the Animal Health Act, the Animal Welfare Act, the Boilers and Pressure Vessels Act, the Building Codes Act, the Dairy Producers Act, the Dog Act, Electrical Inspection Act, Elevators and Lifts Act, Farm Machinery Dealers and Vendors Act, the Farm Practices Act, the Grain Elevators Corporation Act, the Lands Protection Act, the Natural Products Marketing Act, the Planning Act, the Plant Health Act, the Stray Livestock Act, the Unsightly Properties Act, the Veterinary Professions Act, the Weed Control Act, and the Women's Institute Act. So based on our recent experience with COVID-19 and the restrictions that were put in place, we believe there are important factors to consider in terms of statutory requirements for commencing or taking proceedings, statutory requirements for the holding of meetings, and statutory requirements for the particular form and manner of processes and activities. We believe these factors can be impacted when there are restrictions on such things as in-person contact and public gatherings. So turning to limitation periods or specific periods of time for commencing or taking steps in proceedings, we have at least 22 acts that contain limitation periods or specific periods of time for commencing or taking steps in proceedings. So, for example, this includes Section 9(1) of the Agricultural Insurance Act, which requires that not later than June 30th in each year, a report by the board on operations during the fiscal year ending on March 31st must be forwarded to the minister, who will lay it before the Legislative Assembly if it is then in session, and if it is not, then at the next ensuing session. Section 7(1) of the Dairy Producers Act requires that an annual meeting of each district club shall be held during the month of December in each year at a time and place designated by the District Board of Directors. Section 5 of the Elevators and Lifts Act requires that every elevating device shall be inspected by an inspector at least once annually, and more often when the chief inspector considers it advisable for reasons of safety. Continuing, Section 2(1), 2(5), and 14(2) of the Dog Act. Section 6 of the Farm Machinery Dealers and Vendors Act also contains limitation period provisions. Other sections of acts that also contain similar limitation periods of time for commencing or taking steps in proceedings include Section 28(1), Section 32, and Section 39 of the Agrologists Act, Section 1137, 12.3, and 19.6 of the Animal Welfare Act, Section 3.12 of the Animal Health Act, Section 7.2, 25.5, and 28.1 of the Grain Elevators Corporation Act. Continuing on, we have 6 sections in the Farm Practices Act, 7 in the Farm Registration and Farm Organizations Funding Act, 3 sections in the Lands Protection Act, 12 sections in the Natural Products Marketing Act, 4 sections in the Planning Act, 1 section in the Plant Health Act, 1 section in the Unsightly Properties Act, and 4 sections in the Veterinary Professions Act. All of these sections deal with, to some degree, the limitations of periods of time for commencing or taking steps in proceedings, and in total, there are approximately 73 sections that contain limitation periods, or periods or specific periods of time for commencing or taking steps in the department's legislation. So now I'll move on to sections of acts and legislation that deal with form and manner. So there are at least 13 acts that specify the form and manner of certain processes or activities. So for example, Section 10.2 of the Animal Welfare Act states that the director may require the applicant to submit any additional information the director considers necessary. The applicant's premises may be inspected by an animal protection officer or veterinarian, or both, to determine whether the premises and their proposed operation are in compliance with the Act. Section 13.3 of the Farm Practices Act, which deals with the determinations of normal farm practices, states that upon receipt of application, the board shall hold a hearing and determine whether the farm practice or any part of the farm practice is normal. Furthermore, Section 5.1 of the Unsightly Property Act, which deals with the service of orders, states that one of the means of serving orders can be in person by delivery. Section 7.5 of the Dairy Producers Act, Section 2.4 of the Dog Act, and Section 6.1 and 13 of the Elevators and Lifts Act also contains provisions for form and manner of certain processes and activities. Section 9.1 and 2 of the Plant Health Act cover provisions for contraventions or violations of the Act and the form and manner by which these may be restrained by injunction upon application to the Supreme Court. Continuing, there are 5 sections of the Farm Practices Act that deal with form and manner to some extent, 2 sections in the Farm Registration and Farm Organizations Funding Act, 2 in the Natural Products Marketing Act, 2 in the Planning Act, 1 in the Dog Act, Stray Livestock Act, Veterinary Profession Act, and the Weed Control Act, respectively. In total, there are approximately 25 sections included in the department's legislation that include requirements for various form and manner of processes and activities. So finally, just turning to the requirements to hold meetings. So there are approximately 8 acts that require the holding of a meeting. So for example, Section 10.3 of the Planning Act states that the council of a municipality shall, before adopting an interim planning policy, hold at least 1 public meeting in order to give an opportunity to residents and other interested persons to make representation. Section 11 covers requirements for the holding of public meetings, particularly with respect to opportunities for public input and for interested persons to make representations. Similarly, Section 18 requires that before making any bylaw, the council shall give an opportunity to interested persons to make representations. Section 5.1 and Section 14.6 of the Agricultural Insurance Act also includes provisions for board meetings, as does 11.1 and Section 16F of the Agrologists Act. Other acts that contain requirements to hold meetings includes the Animal Welfare Act, the Dairy Producers Act, the Farm Practices Act, the Veterinary Profession Act, and the Natural Products Marketing Act. So in range, there's approximately 10 sections of the department's legislation that include requirements for meetings, and this is in addition to over approximately 30 sections of regulations that include requirements for meetings. So I'll now turn it back over to Deputy Matheson for some concluding remarks.
Great, Bob.
So overall, the department was able to maintain the majority of its statutory responsibilities throughout the pandemic. Legislative challenges included requirements under the Planning Act, the Boilers and Pressure Vessels Act, and the Elevators and Lifts Act. From a planning, research, and good governance perspective, it is important that high levels of policy capacity are applied when considering permanent changes to statutory requirements. This requires rigorous analysis, consultations, and coordination of impacted parties to determine which statutory requirements for meetings, forms, and manners and limitation periods need to change. Most importantly, government processes need to be agile to be able to quickly react to situations such as COVID-19. It is difficult to know exactly what challenges may be encountered during states of emergency, particularly in terms of government statutory requirements. As mentioned, Section 11 and 18 of the Planning Act covers meetings under municipal authority with official plans and bylaws. Throughout the pandemic, approximately 11 meetings were postponed because of restrictions. The department is currently completing research to see if there are ways that meetings may be able to take place virtually while simultaneously upholding the principles of public access and inclusion for important planning decisions. An amendment to the Act could be considered after careful research and consultation. Various sections of the Boilers and Pressure Vessels Act, for example, sections 10(1) and 21, include requirements for the inspection of boilers. The closure of facilities make it difficult to complete regular inspections of boilers. Inspections are now occurring as facilities are reopening. Similarly, under the Elevators and Lifts Act, Section 5 requires that every elevator's device shall be inspected by an inspector at least once annually and more often when the chief inspector considers it advisable. The closure of facilities make it difficult to complete inspections on time. Inspectors were not able to enter buildings. This will impact inspection scheduling moving forward. For example, there may be increased inspections to ensure that there are no gaps in inspection moving forward. In closing, as articulated by my colleagues in Justice and Public Safety, if our department knew what legislation needed to be amended in advance of an emergency, we would identify or already have identified those issues and undertake the work to complete those amendments. To appropriately meet the needs of Islanders in an emergency situation, it would be beneficial to have a mechanism to temporarily address those legislative issues that we have just recently identified and issues that have yet to be identified. So I'd like to thank you for the opportunity to present today.
Great. Thank you. Thank you very much. So at this time, you went through your presentation was thorough. We'll open the floor to questions by members. Brad Trevors.
Well, first off, thank you for taking the time to come in. I know all departments are extremely busy. I would just wonder, just to be clear, and just for the record, from your department's perspective, which approach would you recommend to legislation at this time? Would you prefer to see Bill 37 move forward, amending the Emergency Measures Act, or do you think that you'd rather see some sort of process go forward to amend the pieces of legislation that you've outlined? And maybe you can comment that on a short-term and a long-term perspective.
Easy questions to start.
Well, I would say on a long-term basis, as we kind of mentioned in our presentation, I think there's a lot of policy and research that goes into making long-term permanent changes to legislation. However, I think it's our experience in the pandemic that the short-term changes that are temporary in nature, it's nice to have that flexibility and ability to act quickly to make sure that we're meeting the needs of Islanders, that we're upholding the rights of Islanders, and that we can do the work that we're kind of charged to do within the department.
Perfect. Okay. Brad Trevors. Okay. Anybody else in the committee? This is Trish Aldez.
Thank you, Chair. And thank you so much for your presentation. It really did give me a very good sense of exactly what your experience has been so far, and you clearly have you were well prepared for this, so thank you for that. You mentioned, I believe, there's 22 acts of the 24 that have some sort of limitation period in them. I think you had said that. I think it was also mentioned that some meetings had to be postponed, so I don't know if any of those meeting requirements or limitation periods were passed as a result of COVID or not. I'm not sure if you mentioned that.
No, they haven't been passed as a result of COVID. So part of the issue is it's with the Planning Act. I think it's sections 11 and 18. Mm-hmm. We are doing some research on that now to find out what would be acceptable as a means of a public meeting. There are very strict terms and very strict requirements for having a public meeting when it deals with changes in bylaws for municipalities or when it changes in land ownership or those types of things. So we haven't brought those forward as of yet. We're still working through that process to determine what would be acceptable with the courts. So that's why we haven't brought that forward at this point in time.
Okay.
Trish?
Thank you, Chair. Okay, thank you. So at this point then, if, as you're trying to figure that out, if it takes a long time and you're not able to do it before the period passes, the time frame that you need to do it within, what are the consequences for that?
The consequences of not being able to hold public meetings are that bylaws can't go through, changes in plannings for municipalities can't go through. It may slow down construction, which in a case of trying to come out through the other side of a pandemic could cause delays in our economy up and moving again.
Trish, yeah.
Thank you, Chair. So you mentioned you're already in the process of seeking legal counsel and planning to bring this forward. Should we, in an event that we are able to have virtual meetings of the legislature where you could bring it forward in, sort of the current method of doing so without having to circumvent the legislature and have it go just straight to cabinet, is that a process that you're currently preparing for, I guess?
For the Planning Act, I would say we are planning to do that. We are planning, because it is, it's a bigger scope and we have to do some jurisdictional scanning across Canada to see what will work and what won't, what's acceptable and what's not. For that particular piece, we probably would be coming through the legislature to do that.
Okay.
Trish Altes?
Thank you, Chair. So it sounds like there's some more complex changes as well that would need to go beyond the span perhaps of the sunset of clause in the Act we are discussing here of 2021 as well, right?
For the Planning Act, yes,
For the
it would be
Planning
more
Act,
complex,
okay.
yes. Yeah.
Right.
Trish?
Okay. That's all for now, Chair. Thank you.
Hannah Bell?
Thank you, Chair. Yeah, around the Planning Act, to be clear, the requirement is for public meetings to be held. Am I correct?
Correct. When there's a change to a bylaw or when there's a change to their official plans, then yes, there are requirements for sections 11 and 18 in the Act.
Okay, because thank you, Chair. Yeah, so I'm kind of thinking about, in the context of an emergency, we're not just talking about the requirement that be held, but the fact that people couldn't attend even if you could hold it, which is the issue. We can't make a change that would allow people to break the public health order, for example, to attend in like we are currently. And so I see the complexity is not just permission to not have the meeting, but it's how do you then create an opportunity for a meeting to be held in a situation where people aren't allowed to gather in numbers, for example. So I can't see a kind of a quick fix to that that could be done by a decision in cabinet, for example, because the cabinet couldn't override the restriction on the public to not be able to attend that meeting. So you're talking about having to create a virtual space for people to actually attend the meeting itself. Am I correct? Is that
correct? And we
right?
are looking at other jurisdictions, because I think it has happened in other jurisdictions where they actually have. I think BC might be an example of where it actually has happened. They have had alternate ways to hold a public meeting without actually having face-to-face. So we're looking at research to see whether that would be applicable here to PEI. If that's applicable, then cabinet. In that particular instance, it would work on the short term if something like that could be accepted and could be considered to be acceptable and meet all the rights of islanders and make sure that they have the ability to publicly provide their input and feedback to one of the municipalities.
Sure.
Annabelle?
Yeah, and I'm interested in it also because of the same discussions that we're having around the meetings for the legislature on a virtual basis, which are much more complex than they initially sound, because we have to ensure that the consistency and quality of the representation is accurate in terms of a vote, for example. And so I understand it's way more complex than it seems. And people saying, why don't you just do a Zoom meeting? It doesn't quite work that way. So, I'm hearing then the two different pieces to it. One of them is the ability to sort of temporarily allow that difference in a meeting, but also then what is the provision of how that meeting meets the requirements on a legal basis and on a participatory basis for those involved. Question of the chair, if I may. So. Again, sort of more of a kind of a future look, but is there on a long-term basis, are you thinking about that being an option in the legislation, so that you would still, in this legislation, you would still want to see people have, the primary route being that people do get together physically, but then this is an alternative method that could be employed without penalty?
I think what we're looking at right now is, one, we're looking for an option that will work in the current pandemic state to make sure that we're meeting all requirements and that people's ability to provide feedback is there. The second piece, I think, is long-term, to look at more of a modernization of what a public meeting might be and how it might work, with fully being aware of some of the I don't want to call them deficiencies, but the concerns that you had pointed out about the ability of everybody to come to be able to participate, to make sure the forum is all-inclusive, to make sure people have the opportunity to come forward. So I think we're looking at a couple different pieces, what we can do in a pandemic to make sure that work can keep going and people can be heard, and I think long-term what a modernization of a public meeting might look like. I hope that answers your question.
Annabelle?
Thank you, it does, and it's, again, difficult questions in these things, because we're talking about a lot of what-ifs and things, but in the context of the pandemic, where we have a public health restriction on the number of people that can physically gather, and you have legislation that requires the two pieces, that the meeting happens within a certain condition, and that the meeting looks a certain way in terms of people gathering, what order or change could be made in the short term that would allow that to happen in a public health environment?
And that's what we're doing research on right at this point in time, to see what other provinces have put in place. I don't think we have an option on the table at this point in time. Now, the Communities and Fisheries will be coming to present to you later today. The Planning Act falls within our ministry. However, the responsibility for municipalities and making sure that they check all their boxes and do what they're supposed to falls within the Minister Fox's area. So they might be able to answer a little bit more questions about what some of the options are, some of the provisions might be, because they've been working on that as well in their office.
Annabelle?
I appreciate that, because I was going to ask why the Planning Act was a little, some of them are a little odd, that I must admit, it's sort of a strange mix. I guess the point I'm making is that in the current status, if we had the opportunity to make an executive order, I don't see what the executive order could be.
Sorry.
Yeah, no, that's okay.
Okay. So at this point in time, we probably don't know. However, the Ministry of Communities or Fisheries and Communities, they may have an option that they have on their plate that they're aware of, that we're not aware of at this point in time. We as a department are more looking at the long-term modernization of what a public meeting might look like, whereas the Fisheries and Communities are more looking at right now what could be included and what could work and what could make sure that the rights of islanders are taken into account, to make sure that they can have their say in changes in the municipalities.
Annabelle?
So my last question. So yeah, and obviously this has context. The planning, the meeting piece comes up in a lot of other legislation, the same way that the time limitations do. It's a really consistent challenge, and so we spoke with Justice briefly about that long-term plan of modernising legislation on a general basis, knowing that legislation generally needs to be refreshed, and this is sort of probably one of the bigger pivots that we're going to see of responsiveness for the unknown, but that how the amount of work that's required for that. And like you said, I think really appreciated that you talked about that thoughtful and long, thoughtful consultation and development to make sure that it is right when we make those big changes. My challenge is just sort of recognizing the difference between situations that we can address with a short-term decision, like whether it's made in executive or in the legislature, and challenges that we actually just can't address because we don't have the technology or the means to do so right now. And in the same way it is for the legislature to meet virtually, it would be great to make a decision to do that today, but we actually can't because we don't know how. And I think that's an important nuance here when we're talking about meetings in particular. We can make a decision that we should do a meeting a different way, but we don't actually have the tools currently, as far as we're aware right now, to do so.
Right, and as I say, the Fisheries and Communities are looking at that, and they may have some other examples in other jurisdictions that may work and may fulfill the responsibilities, but for us right now, we're looking more at the longer term ability of those face-to-face meetings. There are other meetings that are in here that don't specify face-to-face and don't specify having to, and some of those could be adjusted, but the Planning Act in particular, yes, I agree. I think it's a two-part question there.
Yeah, definitely. No, thank you, Chair. That's helped clarify that for me. I appreciate it.
Great. And I just had, I think this is great, limitation periods, form and manner, and then some of the things that you talked about with the inspections, the inspection issues about elevators, and that would seem like it would be something that I'm sure your department has struggled with. During COVID, were you not, you weren't allowed to have access to the building, so that I'm just trying to think about workarounds. Could you talk a little bit more about what you did what were some of the roadblocks about inspecting elevators that you came in contact with over the last 3 months?
Yeah, I can provide a little bit of context to this. So we were in touch with our director that's responsible for this act. So as you said, it was the closure of buildings that sort of limited access, which created a lag in some of the inspections. And sort of the plan moving forward with that is that there's going to be, now the facilities are opening back up, so that there's not a greater lag, there's going to be increased inspections. I think the exact number, that were postponed following for whenever buildings open back up was around 4 that were postponed. But then the other annual inspections that weren't performed are going to be done now that buildings are opening back up.
Yes, sir, please.
Yeah, so one of the concerns too was not only the buildings not being open, but a lot of these inspections take more than one person. So with the social distancing, it's pretty hard when you're jammed in an elevator shaft to do the social distancing. So we'd have to find different provisions there. And I think probably moving forward, what we've learned there is probably maybe provisions in the maybe the health order that would allow us to get into some of those buildings a little bit easier might be something that we would look at, I would think.
Yeah, and that's where I'm kind of going. That's why I think this committee is really beneficial this week, to find out what the issues were and to make sure that you have support moving forward with that, because it would seem that a lot of times, like when you're looking at inspectors in this nature, that they become more or less an essential worker and should be identified at that if we head into another COVID, because when they're not doing that, I mean, creating a lag is one thing, but having the staff and resources in that such an expertised area is another. So is there any thought about how to, well, I guess you guys are looking at the legislation, so but that was interesting, and I'm glad that you mentioned that here today. I'll open it back up for a second round of questions at this time. So Trish Altez.
Thank you, Chair. So I just wanted to clarify something as I was sitting and thinking about the limitation periods and the need to meet in a certain way based on the legislation. So, the Act changes, the amendments to the Emergency Measures Act that are on the table would allow you to modify the way a meeting is done, or allow Cabinet to make that choice, or to delay a meeting, right, if necessary.
Yep.
Okay, so I can see that, that's all okay, but what about waiving a meeting completely? Would Cabinet have the ability to make that change?
That would be a question for a lawyer. I would assume that they would have the authority to do that, but not being a lawyer, I couldn't tell you. Yeah.
Trish?
No, thank you, Chair, and that's fair enough, and it's just, as we're learning and listening, to all of the challenges that come up, new issues are coming, coming forward, or questions that I have, so it's fair that you can't answer it, but maybe we can figure out a way to get an answer on that, because I think there's a big difference between modifying the way a meeting is done and delaying it even if necessary, and waiving the requirement for public consultation. That's a line, so, in my mind. All right, thank you.
Yeah. Excellent question.
That's all.
Anybody else this time? Yeah, Brad Trivers?
I just wanted to make a comment on that at this point, which is a good one. I think it's important to note that government's going to be held accountable for any of their actions, especially during a pandemic. And so I think it's important to note that the sort of rogue actions, where you might override important pieces of legislation like that would be very unlikely, and it wouldn't be in the best long-term interests of any government, I wouldn't think.
Perfect. Excellent. Yeah. I guess that's comment. There's no question there, so, yes. So, at this time, if this is your time, we really appreciate you coming. Is there any two pieces of summarization, 2 or 3 things that you would want to leave the committee with? This is your time, and was this a good exercise for your department to get ready for this committee? Those would be the last.
I think it was a good exercise for us to kind of evaluate what impacts COVID has had on the department, and I think we've come up with a really comprehensive, good document here. One thing I would point out, I guess, is we don't kind of know what we don't know at this point in time. So I think a bill like this would be very beneficial, and I'll kind of use the Animal Welfare Act as an example where it might work for us. So if we issue an order or a seizure of animals under the Animal Welfare Act, the animals will be looked after at that time. There's no impact on the animals as far as the protection of the animals. However, the rights of the person under who was served the order or whose animals were taken has the right to appeal under that particular option. The appeal period is a very short period of time, and with COVID, they may not have the ability, or a pandemic, they may not have the ability to go out and get the information or get the reply in a manner that is adequate time for them. So I think in a particular case like that, they may not be heard appropriately. And on the other side of things is the board itself has a period of time which they have to have the hearing or hear the appeal by the applicant and then make a ruling on that. And they may not have the resources or the ability to make that ruling. So I think in a case like that, both from a board perspective and from a public perspective, to have the flexibility to make adjustments to those time periods that would be in the best interest of both, I think would be valuable. I would say we would say that. Did you have anything, Bob?
No, and I would just agree with Deputy Matheson that, well, one, it was a good exercise in that it required us to review all of our legislation for particular impacts with respect to the pandemic. And I would just sort of also reiterate that, you know, in terms of long-term changes for statutory requirements and, you know, and thinking about, you know, beyond the pandemic, that having the proper research, consultation, and time to do that sort of thoughtful analysis is really, really important. So in the short term, it is really important that during pandemics, we're able to be agile and react quickly. And I think that's really what this exercise was about, was looking at what would be needed only for the short term.
Excellent,
Yeah.
excellent, perfect. We just have Hannah Bell.
Thank you. I guess it's following on from your comments there, is the absolutely, you know, the short term, knowing that we've been talking quite extensively about the second wave and about that this is a longer term thing that we're in, and not knowing, like you said, we don't know what we don't know. We do have some clues about, you know, how some of the things that we'd never thought we had to plan for before, like what do you do when you can't actually put people in a room together, and that kind of piece. And one of the things that we'd spoken about in the last committee meeting was that this is our new normal in many ways, is what used to be comfortable is no longer assured. So on that basis, are you looking, or perhaps is there something on your radar now, or perhaps with more focused approach to updating the legislation that you have reviewed and looking at sort of where the priorities are on that long-term basis, because that's something we spoke about with Justice as well. And perhaps you could speak to that, because I know it's always on the agenda, the refreshing of legislation, but sort of what would that look like because of this exercise?
Absolutely, and I would say that everything that we're doing would have a pandemic lens on it. I would say that over the long term, with what Bobby kind of mentioned about the research and the consultation and the jurisdictional scans and all that type of work is critical. However, in the short term, I think with a finite period of time to help us actually get the work done currently, it would be nice to have that flexibility on the short term, while at the long term, as you say, with this new normal, having the ability to adjust the legislation on the long term based on a longer policy-driven process, yes.
Right, yeah, that's great.
Hannah Bell?
Do you have sufficient resources to be able to do that within your current scope, or is that something that, again, longer term we need to think about?
I think Bobby has a very strong policy unit, so I would say long term we definitely have the horsepower to do that. I think we have the resources to do that, and I think this is the first exercise in us being able to kind of put those pieces together and see what would be a short-term, what would be a long-term, and what provisions we may want to look further at to other jurisdictions to see what they have. So maybe we can adopt it, would give us a little bit more flexibility.
Great. That's it, I'm good, thank you, Chair.
I think that was, and again, on behalf of the committee, we know that your weekend was probably pretty full. So, and we appreciate it, and this is a good exercise for all Islanders. So thank you very much for coming in today. We'll take a break until, I think we'll take a break till 10. So you have a 20-minute break, and then we'll be back at 10. Okay. Thank you. this is the Standing Committee on Health and Social Development. We're in part one, our second presenters for everybody who's watching at home, and we're considering Bill number 37 that was referred to this committee in motion number 75 in the Legislative Assembly. So what we'll do is our second presenters at 10 a.m. we're going to be hearing from Economic Growth, Tourism, and Culture. And we're excited to have our presenters here today. And we have the format, just to let the presenters know. You'll have a 10-minute opening statement, give or take right around those times, followed by 25 minutes of questions by members, 5 minutes each. But normally we give time for other members, but there are none here today, so we're kind of flexible with that. And then we'll do a 10 to 15-minute recess following the presentation. So at this time, what I will do is I'll pass it over to our guests to introduce themselves and start into their presentation. Thank you.
Sure. I'll introduce myself. My name is Jeff Collins. I'm the Legislative Coordinator for the Department of Economic Growth, Tourism, and Culture, and I'm the Trade and Economic Policy Advisor for the department.
And I'm Patricia McPhail. I'm the Director of Labor and Industrial Relations. We have some special legislation within the department, so that's why I'm here.
Perfect. Thank you very much. Great.
So, Chair, we can begin if you want.
Yes, absolutely.
Sure.
Thank you.
Well, good morning, Chair and fellow committee members. Thank you for inviting us here to present on behalf of our ministry. We are here today to present information on 3 issues: acts under the Department of Economic Growth, Tourism, and Culture's area of responsibility, how the pandemic impacted operations of the department, exclusively in relation to the impact of legislative barriers on the department, and to identify those acts which could be researched further to determine if amendments are needed to accommodate a state of emergency. There are 23 acts under the responsibility of our ministry, the Department of Economic Growth, Tourism, and Culture, and I'll just go through them. We have the Area Industrial Commission, which allows municipalities to establish an Area Industrial Commission. We have the International Interest in Mobile Aircraft Equipment Act, which implements provisions of an international treaty signed on behalf of the federal government. We have the Maritime Economic Cooperation Act, which sets a commitment with the maritime provinces to work together on economic cooperation. We have the Apprenticeship and Trades Qualification Act, which sets out the regulation of trades qualifications. We have the Labor Mobility Act, which implements internal trade provisions regarding labor mobility. We have the Finance PEI Act, which establishes the Crown Corporation Finance PEI. The Island Investment Divestment Act, which establishes Crown Corporation. The Innovation PEI Act, which similarly establishes the Crown Corporation Innovation PEI. We also have the Heritage Places Protection Act, which establishes and maintains an inventory of heritage places. We have the Lucy Maud Montgomery Foundation Act, which establishes the foundation. We have the Museum Act, which leads to the creation of the PEI Museum and Heritage Foundation. The Fathers of Confederation Buildings Act, which establishes the Fathers of Confederation Memorial Citizens Foundation. The Highway Signage Act, which provides for the control of the erection, display, maintenance, and placement of signs that are within view of a highway. We have the National Park Act, which is the authority to inspect and survey private land related to the PEI National Park. We have the Recreation Development Act to promote and encourage orderly development of rec facilities and rec services, like provincial parks. We have the Tourism Industry Act, which encourages and promotes improved standards of tourism establishments. The Tourism PEI Act, which creates the Crown Corporation Tourism PEI. The Trails Act, with the purpose of that act is to provide for the establishment and operation of trails on Crown lands for recreational use and employment. And that's just a tease. The Workers' Compensation Act, which sets out the obligations of workers and employers and provides for board governance. We also have the Occupational Health and Safety Act. And finally, we have the Employment Standards Act and the Labor Act, which my colleague Patricia will speak to later.
And the Youth Employment Act as well.
Youth Employment Act, oh yes, that's page 7, right. Youth Employment Act, right. That's 23 of our pieces of legislation in our ministry. So based on the ongoing experience of COVID-19 and the restrictions that were put in place, our preliminary review with the respective statutory leads across the Department of Economic Growth, Tourism, and Culture, and its affiliated Crown corporations and agencies indicates that with few exceptions, the department met its statutory operational requirements. For the most part, existing statutes and associated regulations gave us the policy flexibility to continue despite the restrictions put in place due to the pandemic. For example, Crown corporations like Finance PI, Innovation PI, Island Investment Development Inc., and Tourism PI have statutory requirements for board meetings, but, as in the case of Article 8 of the IPI Act, there is no stipulation that meetings be in person. There are no statutory public meeting requirements for these Crown corporations either. Similarly, several acts stipulate the power to impose and collect fees, but the specifics on these are laid out in regulations, therefore preserving policy flexibility. For example, Articles 8 and 9 of the Highway Signage Act, Article 2 of the Recreation Development Act, and Article 2-3 of the Tourism Industry Act. Our preliminary review did note some exceptions where the proposed Emergency Measures Act amendments could be of value. For one, I look at the Lucy Ma Montgomery Foundation. It has a specific article 7.2, and it requires that the board shall meet at least once a year at the birthplace of Lucy Ma Montgomery. I'm currently working with Dr. Matthew McRae of Museums and Heritage Division within our department to understand the Foundation's perspective on this and to see if they had meet or if they plan to meet, and if so, what's their opinion. Regarding the Workers' Compensation Act, Section 34 requires there be an annual report before June 30th of each year. The board is planning to have this in place by July 23rd, given the complications that have arisen from COVID. Also, there is an appeal section in the Act, Section 56, that refers to a 90-day appeal window, but the board did not encounter any difficulties here during the shutdown and did not hear from any clients in this regard. The Workers' Comp Board believes that they are not been obstructed due to the COVID crisis. I will now turn over to my colleague Patricia McPhail to speak on statutory issues arising out of the pandemic as it relates to the Labor Act and the Employment Standards Act.
So I'll start first with the Labor Act. My preliminary review of the Labor Act suggests that there's sufficient flexibility built within the legislation itself, giving powers either over to the Minister or the Labor Relations Board, as the case may be, to extend, or between the parties and as well, to extend deadlines that are specified within the Act. However, it is possible that there's something within the legislation that I missed in the review that could become problematic should we experience another shutdown of services. The Employment Standards Act, during the pandemic, we did know that there were some concerns regarding the strict appeal deadline for employment decisions, employment standards orders. There is a strict 10-day appeal window, which the Employment Standards Board has no flexibility to adjust at this time. This could either be corrected through a change to the legislation, but in the interim, having the ability to suspend that limitation period would be useful. The other portion of the Act, which we are still trying to determine how we're going to work through this with the Employment Standards Board, is how to complete the annual review for minimum wage orders. The new provision under Section 5, subsection 2 requires that the board meet at least once a year and consider both written and in-person submissions. The difficulty right now is how and where to host meetings for the in-person aspect of the submissions. The written one shouldn't be a problem, but it's that in-person aspect that we are concerned about currently, and there's no flexibility to adjust that under the legislation right now.
Thanks, Patricia. I should note that we're still, given the weekend that just transpired, we're still reviewing the OHS Act to see if there is any implications from an operational side related to the questions you provided, Chair, last Thursday. So when we get that information, we'll confirm either way. So having said all that, the department was able to maintain the majority of its statutory responsibilities throughout the pandemic. Of course, determining whether statutory barriers to the department operational needs need to be varied during a state of emergency is very much context dependent. And this was very much a preliminary review. So with those caveats aside, I'd like to thank you for the invitation to present, and we look forward to your questions.
Great, perfect, thank you very much. Perfect. So at this time, I'll open up the floor to our members. Who I didn't introduce here, by the way, to our guests. We had Jamie Fox, Brad Trivers, Hannah Bell, and Trish Altez, and my name's Gordon McNeely. So we're this committee. So at this time, is there any questions from the floor, from the members? Hannah Bell?
Thank you. Thanks very much. It's good to see you. Chair, I should have asked this previously, but I'm reminded of it today, when our presenters have done that review of legislation, is that something that we're able to get as a copy, or is that confidential within? How, like, is it something that could be shared as documentation for the committee to refer to at a later point?
Yes, and we haven't really discussed, we stayed fluid with what we wanted to ask, but we didn't ask about in their deliberation if they would like to, would that be make a submission or give us all the notes that they had during the...
Yeah, Chair, I mean, I'm particularly interested in the summary of that summary of the acts. I think we've seen each department do it, and it would be really helpful because, again, part of, well, I don't know, speaking for myself personally, it's learning about which acts fall under which departments and then what those overall themes are that they're finding. So I don't know whether that's something, it's not specifically for the guests on the floor, but more to the Chair and the committee. Saying that to the guests on the floor, I do, we're hearing already seeing some themes which are specifically around time limitations, and then the meetings piece seems to be the recurring side. With the time limitations, one of the questions I have is you mentioned some of those in your acts, some of those they're under regulations, so you have that flexibility versus the ones. How does that happen? Is there a logic to, or is it just more?
It's a good question. I think for our ministry, of course, we expanded quite a bit over the last year and a half, taking on other agencies and boards, but some of the acts are more recent, and therefore they have very similar wording that allow for that policy flexibility, which is pretty standard. If you board operations are generally something that should be left to regulations and bylaws. It's not something generally you put specifically into an act to stipulate, unless it's probably a reporting requirement. So that would be my preliminary guess. Some of this legislation, and I should say, Chair, this has been a useful exercise to stand back from a high level and kind of look at it. Even as Ledge coordinator, when I'm dealing with work plans, it's really the immediate acts that are on my desk relate to the work plan. I don't normally look at the whole breadth of legislation. So some of our acts, for example, go right back to the 90s, and in some cases even trace the origins to the 70s. In some cases, the wording is still in there as it related to back then. I think more modern contemporary views of how this right legislation would allow, that's, as a standard, to have flexibility and port operations separate in a regulatory space. So that would be my initial impression.
Annabelle?
And I thank you for that, because that's something that I've been thinking, just even in the first bit, that there's a very big difference between sort of like a Crown Corp, and the requirements, or something where you're doing like a review. I think about the meetings for setting the minimum wage, or some of those other pieces which have a very specific set requirement of time limitation versus the time limitations around things like board meetings. And so it's when we've talked a bit about sort of what that future-proofing of legislation and that review and revision, that could be a recommendation that we could consider without being prescriptive. For sure. Right. But from a policy perspective, it makes sense that regulatory flexibility is there which could provide some greater responsiveness.
Right.
When you speak around the public meetings in the previous presentation, we had talked about the double challenge of a time requirement for a public meeting or a condition for a public meeting, but also the challenge of actually having a public meeting when there is something like a public health emergency. Right. Which legislation was it? Just the workers' comp one that had that requirement? I'm sorry, I missed it.
Patricia's legislation actually had a public meeting with stipulations.
So the Employment Standards Act had that in-person submissions must be considered for the annual minimum wage review.
Right.
That was the one that was referenced.
That's the one I should know about, because I did the amendment to it. Okay, and that is both a time required one and a in-person one. Is your department then considering, as we've heard perhaps for other departments, some of the alternative options for how a meeting could take place?
relate to a public meeting?
Yes.
Patricia?
That one's difficult. With the language that is actually in here requiring it to be in person, I'm not sure what the alternative could be. So we're still working on it. They have started the process for the annual minimum wage review. It's quite a few months go into the background work. Predominantly, the submissions are made in writing anyway, so I don't know what the answer is right now. We are still looking at this because we're only just getting the ball rolling.
Yeah.
And by we, I mean it's really, it's not to me, but it's the Employment Standards Board themselves, but they have support from staff within my office.
Okay.
Annabelle?
No, thanks, Chair. No, thank you for that. It's, yeah, I guess it's that large, we're seeing some themes again, that larger challenge of sort of how and what tools are available to sort of address that kind of logistical concern versus a legislative, but it may be stated in legislation, but it's actually a logistical issue rather than a decision issue. You know, I'm hopeful that in some of the work that this committee is doing in that pulling those themes, that we may get to the point where we can make recommendations that actually help the whole of government by, you know, by seeing those things that are across the board, across departments. The last question I have then regarding your legislation, what kind of time, like we heard about sort of the short-term issues and longer-term issues. I'm not hearing as many short-term issues for your legislation right now, other than this, particularly the one here. What does that look like for you in the planning in terms of short-term, long-term?
It's a good question. It's a kind of a tough one to answer, right? I don't think 150 days ago we would have seen, as the legislation was designed, I don't think it was designed with this type of external test. Fortunately, on the upside, it's showed so far, for the most part, with the caveats we've just given, a couple of pieces, and I'll get back to the chair later on the OHS Act, but it's held up pretty well in terms of offering the operational flexibility. It's hard to say if we had to do this again and again be more constricted than what we were even mere months ago, what that would like. I think as this event has highlighted our ability, it's highlighted the fact, the importance of having statutes written in a way that allow for operational flexibility. So it's hard to say what a future second wave, as it's been often talked about, will mean and what it will bring to the fore. But I'm afraid that's the best answer I can give right now.
Annabelle?
I just have one other question, and it's just because you're here, I can ask you. My understanding in terms of, like, we see a lot of reporting periods that require the reports to come in July. If I can just, I think I know the answer, but I'd like to check it on record, which is that fiscal years tend to end March 31, and then an auditing period then occurs after the end of the fiscal year, which means then your report for your previous year would be coming 3 to 4 months after the end of the fiscal year.
June 30th.
Right. June 30th, okay. Yeah, in my head that made sense, but I wanted to check. So it's where organizations are aligning with the government fiscal year rather than an accounting fiscal year, but with the March 31 end.
Right,
then
so Crowns as well. And none of the Crowns, I should note, have indicated to me they see barriers to completing the audits, other than what I mentioned earlier with the workers' comp.
Annabelle?
And otherwise then for non-Crown and sort of more sort of, you know, like non-profit organizations, non-governmental, then we're usually looking at a December 31, and so our reporting is happening more in kind of the March, April.
Yeah, they follow the calendar year.
They follow the calendar year, but Crown Corps are almost, are
They do.
government.
You'll see their annual reports will usually be 18-19 or 17-18, that fiscal year kind of breakdown.
Okay, I much appreciate it. Thank you, Chair, for the opportunity.
Brad Trivers?
Well, thank you, Chair. And so, Patricia, were you on the radio today talking about emergency relief as well? I think you did a great job, by the way. That was
The recording was done on Thursday, but yeah,
Okay.
that was me.
well done. That's an important step forward, an example of some of the legislation that we are changing to help during these times. But I just wanted to talk about the requirement to be in person for a lot. That's in a lot of the legislation, and it seems to me that that's a perfect example of a short-term change where we need the powers right now in cabinet to do that. I mean, longer term, I agree, yeah, we need to look at, what we can do to the legislation. But, this is the sort of thing where if boards need to meet and entities need to meet to make decisions that are crucial in the short term, the Bill 37 seems to be, that's why it's important to address that. And I just wanted your comments on that and see if I'm looking at that the correct way.
I would say your assessment is correct. Ideally, in this situation, because the review has to happen annually, it has to happen before the end of 2020, and it is in the legislation requiring it to be in person. It's trying to find a way to accomplish that while fitting within the logistical barriers that we have right now. Spacing is an issue. We're still not sure how this is going to be accomplished at this point, but we have started the process for the minimum wage review regardless, because we're going to be taking in written submissions as well. But ideally, we would be able to put that, at least that in-person submissions aspect, on hold for the time being.
Great. Brad Trevors?
So if and when Bill 37 passes, then that would make your job a lot easier and you'd be able to have that review and move forward and make that happen, right?
Yes, if we could do it if we could do it just with the in-written submissions this year, that would be the easiest way forward for this particular year. It wouldn't have to be like that long-term per se, but just as a one-off.
Brad Trevors?
And I mean, this is the challenge we're facing with the Legislative Assembly itself and the ability for the Legislative Assembly to meet virtually. And I know the chair of the Rules Committee hasn't even been able to really address that yet. And so it takes time, and it's tough to address in a long-term fashion, which is why we need to be able to address it in the short term to make things happen. So, thank you, Chair.
Thank you, Brad. Trish Altas?
Chair. I just want to go back to something that Hannah mentioned, that I agree, we're starting to hear some themes coming forward, and just what I think is a simple question, and just to make sure I didn't miss anything in the presentation, have you identified any issues or challenges that were not related to either time limitations or requirement for in-person meetings within a certain time period?
So in the sense that outside of statutory barriers, through other implications and operations?
Yeah, just wondering, it sounded like those were sort of the two main challenges that you identified in the examples you gave, were either around time limitations needing to be changed or extended, or I guess as this is connected to that, but the challenge of having in-person meetings when you can't necessarily meet in person. Are there any examples that don't fit in those two sort of areas?
I approached the review based on the questions that were provided, Chair, and so when I went out to the leads, that's the answers I got back related to those questions. I mean, it's something I can go back and ask the leads again, but I'm not aware of anything.
That's okay, sure.
Yeah, Trish?
You don't have to find anything.
No,
I'm just
okay.
wondering,
No,
just for
it's-
clarity, to make sure I understand what
Yep.
the main issues are for you in your department. Okay, that's it. Thank
No
you.
worries.
Great, perfect. Brad Trevors?
And along those lines, just to follow up on Trish's question there, I mean, when you were considering the legislation, in particular to come and report to this committee on the Bill 37, well, motion number 75, were you looking at all those different possible scenarios of various contexts in which an emergency state would have been called and how it would impact the legislation? Or was it more directed towards, the in-person meetings and the time limitations?
Folks were given the specific examples of where there could be possible barriers related to statutes impacting operations, hence the timings, hence the in-person meeting requirements, reportings, things of that nature, but it was also a broadly operational considerations related to statute. So those were the review happened on a Friday, and I was at it all day yesterday. So I can go back, and if we had with people now back in the office this week, I think we could do a deeper dive for sure.
Perfect. Thank you. Brad Trevors?
And I thank you for that, and thank you for the hard work I know this department and all departments are putting in. to make this happen for this committee with motion number 75, with the restrictions that are in place during the pandemic. Like you mentioned, we're just repopulating government offices now. So I think I just wanted to make the point that it's part of the challenge of doing something alternate to Bill 37 during a state of emergency that's actually in place because of the pandemic right now. There are certain challenges related to that, which of course I think supports the case to move forward with Bill 37 for now.
Thank you, Brad. Perfect. I'll just have a few quick questions. The one act that, when you were listing them, that struck me was the Labor Mobility Act.
Yes.
Could you tell me a little bit more about that, and was that act affected during this time?
So the Labor Mobility Act was implemented, it's there to implement a regional agreement on internal trade, which was a domestic trade agreement. That trade agreement was superseded by another domestic trade agreement, that was the Canada Free Trade Agreement, CFTA. So the Labor Mobility Act puts in our legislation our obligations that we made under that trade agreement as it relates to interprovincial, cross-border movement of certain professions. We're in the process of updating the act to reflect that the AIT, the Agreement of Internal Trade, ceased to exist as of July 1st, 2017, and the CFTA has replaced it. So it's really a housekeeping update to swap out AIT with CFTA.
Okay. And then that would seem that, labor mobility did become an issue during, I mean, that's a specific thing, but it became an issue. So I just wanted to see if that act would have, when we closed our borders, that might affect that act.
It's a good question. We're not aware of it. No, so the act really provides under the Canadian Free Trade Agreement, a process to deal with any terms of interprovincial labor mobility challenges. But the real goal is that the respective regulatory bodies handle those type of issues, and it's more of codifying principles about as within one federation that we believe that people should be able to move back and forth. So that's in a nutshell. No, we're not aware of any implications arising from that.
Okay, great. And just another, I noticed that the Recreation Development Act is under you. Could you tell me about what that act is about, and should that not be under health promotion or in health? I'm just, yeah, just.
My understanding that it falls under the remit of tourism PEI. I think the hope there is the provincial parks, which falls under tourism PEI, so hence that's why the act lays there. I think, I'm sure you know, Chair, it's always an interesting, when you look at legislation to figure out where it could land, there's always examples.
Yeah.
You can make a case where this could probably fit in that department, but it could also fit in this one.
Yeah.
So right now it's a tourism PEI.
Yeah, perfect. I just wanted to, no, your presentation was excellent. We have a few further questions. Hannibal?
Thank you. I know that both tourism and innovation at Well and Culture have a number of programs that they offer which have time based on them in terms of them being competitive in nature, or program-based funding where things need to be done within a certain time period. Are any of those restricted through legislation, or are those all done within regulations? So, for example, if a company has applied for funding or a grant where they have to demonstrate the outcomes of that funding within a certain time period, is that something that is legislatively prescribed, or is that all done within the scope of the organizational body?
I don't have the act in front of me. My understanding, with the caveat, I can always, if I find out otherwise, I'll report back, Chair, is that no, those are programs created through regulation and policy, just authorization by the respective Crown Corps to do it. It's not embedded in legislation.
Okay.
Annabelle?
And so you mentioned earlier, sort of Crown Corps have the legislation may set out the scope and the parameters of the organization. The board meeting requirements may be in legislation or in regulation, but the function of the programs and services are then determined by the corporation.
That's right. It gives a lot of flexibility for the corporation to develop programming like we did this year to respond to the needs of islanders in a time of pandemic or any other issue. Yeah.
Annabelle?
And I guess that's part of my question is obviously we did see a phenomenal response from government and a very fast and timely, and appropriate response from government, but that was because the capacity was there for those organizations to respond without needing to come back to the legislature, for example.
Right, yeah, they didn't need to have any amendments done to their respective Crown Corp Acts. They had the flexibility and authorization and mandate to pursue those activities.
Annabelle?
Thank you. I mean, one of the things I'm struck by, and again, it's early days in terms of how many of the organizations, I think you're earlier on the list, but already seeing these themes, and so some of them is about the impact and in terms of what it looks like to an islander.
Right.
So we know how important it is to make sure that we are adhering to the requirements of legislation, but in terms of for an average islander, the delivery of the programs and the services is what matters to them.
Right.
And so the delivery and the program and services happened as and when it was needed. We met the needs of the emergency with the delivery of our programs and services because they could do that without needing this decision. So the legislative impact that I'm seeing, I understand that it's very difficult to sort of say, the legislation says we must have this meeting by a certain time and it hasn't happened, but the impact of that for an islander outside the legislative space is a lot harder to demonstrate compared to can I pay my rent? And so sometimes I think that's something that can be really challenging for us, is trying to find that balance of, we're meeting our what the legal book says we have to do, but the scope of what that looks like to people in the real world is perhaps not the same.
For sure.
When we look at things like time limitations and form and manner, do you see there being priorities, things that would become more of a priority to address rather than others? So I'm hearing, like the minimum wage thing is to me is a priority because that obviously impacts thousands of people. But it's always difficult to say if everything is a priority and nothing is a priority. So
Right.
So what are some of the considerations that your department may be bringing in terms of determining where the priority is and what we address first when it comes to making changes?
Well, leave Patricia to answer. From where I stand and looking at how our department and ministry as a whole functioned, the acts that I've covered, with the exceptions I've prevented, have not held us back from meeting the needs of islanders when we had to do it. Patricia, I know you mentioned about employment standards, but if you have anything to add.
So our rules under employment standards in the Labor Act, they're not so much about providing a service as setting kind of process pieces or regulatory or like regulated minimums, particularly under employment standards. So for the most part, we've been able to operate, but there may be items within these pieces of legislation that we didn't foresee at the beginning of the pandemic, which have cropped up. The minimum wage one is actually one of those things that at the beginning when we were doing the review, didn't note it as being a problem at first, but then as we're approaching the time when we typically start doing the minimum wage review, we saw the issue that was there with respect to the in-person submissions. Under the Labor Act, currently, I don't see any issues, but again, it's one of those, it could come up. So the ability to have some flexibility under emergency situations to put a pause on a particular aspect of it would be important.
Annabelle?
Yeah, thank you for that. I think when we look at the extensive nature of this legislation that's on the table, part of our hope in doing this sort of extensive consultation with departments is to kind of get right down into sort of where are there areas that are of concern that should be addressed first. Is that kind of broad sledgehammer approach, I think, Chair, and you know, it's reassuring to hear that there has been, I mean, I really appreciate the work that you've had to do over the weekend for this, to give us a better picture of where there is genuine urgency or risk versus a potential versus, no, we're okay. And that comes right back to my question at the beginning, Chair, about sort of having that review to remind, after we've had a few of these, I think they're going to begin to blur together a bit, so that will be really helpful. I think a maybe is still something for us to consider, but it doesn't feel at the moment to have the same sense of urgency as for me personally, as the delivery of programs and services on a direct basis, and it's really reassuring to hear that process wouldn't be impacted in any way. So I'm good. Thank you, Chair.
I just wanted to ask a question. Early on, you mentioned the Workers' Compensation Act, and they were supposed to report on June 30th, but then that got postponed till July 23rd. Can you tell me if that is how did you come to that window of time? Was it worked out? Were you able to make those changes in the were they in the regulations?
So this is feedback I got actually this morning from the Workers' Comp Board, in the sense that it's actually stipulated in the legislation that they have to report on that date. The pandemic has obviously slowed things down process, so I was not given a detailed explanation for why July 23rd was picked. I wasn't, but the board feels comfortable that's when they can meet it. So technically, you know, the statute says that particular date they're not meeting, but that's again a complication that's arisen. They don't have technically that statutory flexibility, but they still have to meet the requirement.
Yeah. You know, I'm just trying to find out a best practice, where the best practices are. Was it okay with when the communication lines of communication stayed open, and were you okay with that delay? July 23rd was okay, and everybody was happy to get the report, because we're seeing a lot of common themes that people can't make those meetings, and I think there's flexibility from all sides. And I'm just trying to find some best practices and some workarounds, I guess.
I mean, on a technical aspect, this would be a breach of the legislation. So having the ability, again, to put the pause on that particular mandated hard deadline would be helpful in this situation. Otherwise, it is a technical breach. Now, what impact that has, I couldn't speak to that.
Yeah. And I mean, maybe that might be a question for our committee future on. If it's a technical breach, is it, you know, how does that affect things? And I guess that's what the importance of this committee is. I'm just looking around at my fellow members to see if we're okay with questions. And what we'll do at this time, I've asked the previous guests, this is your time while you're here. If there's 2 or 3 things that you wanted to summarize or leave with the committee, and then at this time I'm going to sign off and say, you know, thank you very much for putting in an unbelievably hard weekend, I'm sure, and we appreciate it. So 2 or 3 things if you want to leave us with, or at this time.
I'll reiterate again what I said earlier, Chair. This was a useful exercise to do, and you know, just to stand back and take a 30,000-foot view of what's going on in the ministry, especially under the changes in terms of our ministry growing. You know, where you can kind of, as a civil servant, you can stay in your silo unless someone from another branch of government, your own department, taps you on the shoulder. You sometimes know what's going on. So it's been very useful in that way. So, and thank you for inviting us to come here and talk to you.
Great, perfect.
And I will just reiterate that this was a preliminary review, so there may be aspects that we did not spot within the pieces of legislation that could become problematic during the period of the emergency. Being able to foresee all of the unintended aspects of it is very difficult, particularly when you're talking complex legislation like the Employment Standards Act, Labor Act, Occupational Health and Safety Act, and Workers' Compensation Act, and legislation, some of which is quite dated. So it can be an issue.
Perfect. Yeah, thank you very much. Well, you did very well today. What we'll do as a committee, we're going to take 60 seconds for our guests to clear the room. There was a question that might require a little bit of discussion from Hannah Bell posed to the committee. So we'll allow you to leave. We'll talk about that question when we come back in 60 seconds.
Thank you.
So do you? Okay, fastest 60 seconds ever. We're back. So there was a question posed by a member of the committee, Hannah Bell, and just wanted to open it up to see if it's something that, is it what we're doing or an add-on? And I think I'll go to the clerk to kind of bring us back up to speed on what that question was.
Sure, thank you, Mr. Chair. And I just want to clarify, I guess, was the ask that the presenters provide like the written copy of their notes that they're speaking from at the meetings? And if that's what the ask is, then I can if it's up to the committee, I can coordinate with presenters on that.
Perfect. Brad Trivers, and then we'll go back to...
Yeah. So it was, I mean, Hannah, you weren't at that first meeting, but I think the recommendation was that every department prepare a written report to the committee so that the ones where there was potentially less impact, we could just waive the requirement of even having them come in. That was my intention. I mean, Trish wasn't agreeing with that too much. I don't think the committee as a whole decided not to do that, but so the written reports from the departments, have we received those?
No, we haven't.
Okay, because I know my department prepared a written report.
Okay.
So I think if we had that written report, I think that would probably fit exactly what you're talking about. In fact, I think that's what the departments are referring to most of the time when they're here.
Hannah Bell?
Yeah, I mean, I don't think requiring a written report in advance is what I was getting at all. I mean, I know people are doing their work and coming in with remarks prepared, because that obviously means they've done their homework, which is fantastic. What I'm asking for is they're referring to those notes. I would like to get a copy of those notes after the fact, like now, so that we have, as we go through these meetings, we have them, because it said, like today, with both of the presenters having that kind of run through of all the legislation and all the different pieces in there. We've talked very clearly already of seeing the themes, and I think being able to refer back to that, because it is going to get more and more as we go through these, so being able to have that as reference point. I don't, given the volume of meetings we're doing, even if people had put written reports in, I wouldn't have had time to read them. So I'm fine with them having that work in writing and us getting that as the material to review, because like I said, I'm pulling themes right now and looking, and that would really help, Chair. So, and obviously I can see they've got it, so it's about asking whether I don't believe there's any confidentiality in that, because they're obviously speaking to it in the committee, and so that would be what I'd be looking for, Chair.
Perfect.
Thank you.
Brad Trivers?
So that's exactly what we asked them for. It was a report of all the legislation that was impacted and how, and there were the 3 questions sent out in the letter to the departments, and that's what they were going to address, right? Mm-hmm. So I guess my question is, I think it actually addresses exactly what we're talking about, Hannah. Even the notes that they have, I think would be part of that report. I'm just wondering, just why we haven't received those reports, or if the departments just haven't come back to us with them. Is that why, or what's?
It's probably, we didn't follow, I don't think we can answer that, because we just sent them what we would like and did the schedule, and then hopefully, I mean, there probably wasn't a whole lot of time, but I'm not sure. I'll defer to the clerk.
Sure, and if the committee likes, I can just, simply follow up with the presenters that were here asking for, I guess essentially the notes that they had at today's meeting, which would then essentially respond to the questions that were in the committee's letter. So if that's something that the committee is agreeable to, I will certainly follow up with our presenters and circulate.
Yeah, we have Jamie Foxx.
That doesn't answer my question about the reports, though. Like, where are the reports? Are we following up with the reports? Because I think they provide the exact information that they have in their notes. Like, I don't think we need to ask for the notes. I think we need to ask for the reports, which we already did, and they've already prepared. Mm-hmm. And that I sort of expected that as each department came, they'd say, here's our report, and then we would have that and they'd
Yeah.
go on. And I'm pretty sure, for example, the Department of Education and Lifelong Learning has done that and prepared it
Yeah.
for today. I'd be surprised if they haven't. I
And
haven't
they're
checked
in,
with them.
they're in at 11, yeah. So,
Yeah.
perfect, yeah.
So I guess I would like to see, just us follow up with the departments.
Sure.
Just for those reports, because I think that would be extremely helpful. And I think it would save us a lot of time on this committee, so we'd get done even more quickly. And I still think that we don't necessarily have to have every single department in, but anyway.
Yeah, perfect. Jamie Fox?
Thanks, Chair. I'm just wondering, Hannah, what are we going to do with the paper at the end of the day when we receive it?
Sorry?
What are we going to do with the paper at the end of the day when we receive it? So if a department,
Hannah Bell?
what's that?
I'm going to do work with it. I usually review with any of the materials I get from committees. In this case, I'm looking at,
Jamie Fox?
Are we filing it with the report we're filing at the end of this?
Hannah Bell?
I don't know, I wasn't in the original planning meeting, so I don't know what, again, like I said, I don't know what instruction was given. It's clear what instruction was given in terms of what people are coming back with. I'm asking for the written documentation that supports what they're presenting so that I can refer back to it when I am looking at what I want to understand. Because often when we're hearing this in committee, sometimes I'm trying to write notes, I'm trying to keep up, and I would like to have that so that I'm not relying on my scribbles to remember what was said. But I mean, in terms of what the committee chooses to do, the committee would discuss that.
Jamie Fox?
And that's what I was trying to wonder, Chair, is a personal request or to form part of the written report at the end for us. That's what I'm trying to figure. So your request is for a personal use of your notes?
I am my understanding was that there was a very clear instruction. I look back at the notes from the meeting that I missed. There was very clear instruction that was given in terms of the questions that the presenters are doing. They're coming in with that information in writing. I am asking whether we as a committee, should we choose to use it or not, that information is shared with us in writing, so it can be emailed or whatever that may be, because it's supporting information like we do in any other committee meeting. When there's a presentation, that's usually shared with us electronically or in hard copy. I would like the same. Again, because I don't trust my memory or my notes, especially if we're doing 6 meetings in one day.
Perfect. Trish Altas?
Thank you, Chair. And I think there might actually be some value in allowing the departments a day or, to provide the written notes to us. I think that the value, or one of the great values of having the departments in to provide a presentation, is that there's the opportunity for us to ask questions. And I think that's been very valuable, and also to identify themes. But if we walk away from a presentation and the department feels that they haven't been able to express exactly what the key issues are for them, or they would like to reiterate what the key issues are that they experienced, I can only see it as a value to have both the presentation and the written report. So I would definitely also, look forward to that, and certainly read those reports to make sure that I have not missed anything in the presentation. So, seems valuable.
Yeah, Brad Travers?
It's a little unclear to me, because the first meeting, that was exactly my intention, was to have that information so we could refer to it, hopefully before the departments got here. But, so did we ask them for reports in our letter?
Yes, we did. Yeah.
Okay, good.
Yeah, we told them that we were under a
Yeah.
14-day timeline and they were to present and.
So I'm just saying, Han, you're gonna get those reports. I don't know,
Yeah.
we're gonna get them anyways. Yeah.
Perfect, yeah. So, at this time, I just brought this question to the floor for the members to say, do we have to go and ask the departments each another question? Can we get your written notes, if that's okay? Because I do believe it's separate from the report, so.
Obviously, I think this is semantics. We asked them very clear things that they were reporting on. They are reporting on that. But I can think the clerk has already clarified that was what was asked for in writing. So perhaps if she can just clarify what the instruction was. I think it's just semantics at this point, and maybe ask the clerk to clarify.
I will go to the clerk.
Sure. So it was in the letter to have the response in advance of the meeting by Monday, June 22nd. So maybe what I can do with the committee is just follow up, reference the letter that we are looking for, the written report, and once those are received, I will circulate to all committee members.
Great. And we will ask, can we ask the two presenters that came for their notes that they used today? Would that be?
Sure, yeah, I can
Perfect.
include that as well.
Yeah, perfect, okay. So, good discussion. I'm sure we'll have more of these discussions as we hear more information, which I think is very healthy. We have 9 minutes before the next presenters are in, so we'll be back at 11. Okay, we'll resume. This is the Standing Committee on Health and Social Development. We're a few housekeeping things that we have the members here today. Peter Bevan is subbing in at this time for Trish Altez, so welcome. Michelle Beaton is here for Hannah Bell for this section. We have Jamie Fox, Brad Trivers, and I'm the chair, Gordon McNeely.
Great.
So welcome, and we're here to discuss the committee's consideration of Bill number 37, an act to amend the Emergency Measures Act. And this was referred to this committee with a motion number 75 earlier last week. So at this time, I'll just tell our presenters that each department will have about a 10-minute opening statement, followed by some 25 minutes of questions, 5 minutes for each member, but we're kind of flexible with that because there's no additional members here today, so we'll be flexible with that. So take your time and then just speak into the mic if you can, or through the chair, and we'll give you the flexibility of getting started now with maybe a quick introduction of yourself, and then the floor is yours.
Sure. My name is Erin Doherty, and I am the Legislative and Planning Coordinator with the Department of Education and Lifelong Learning.
Hi, I'm John Cummings. I'm the Executive Director of Education Services with the Department of Education and Lifelong Learning.
Thank you very much.
Okay.
Yeah, great.
Great. Thank you, Chair. So I will begin. It has been acknowledged that a second wave of COVID-19 is coming. As a result of the ongoing COVID-19 pandemic and second wave, there is a potential for further restrictions on government programs and services, and potential demands to further adapt how we live and deliver on these programs and services. At this time, we cannot foretell to what extent the emergency will be and how long it will last. However, it is important that we ensure that our decisions are informed by experts, facts, and prior learning experiences. Government must work to protect the health and safety of Islanders while preserving their rights and security, and be flexible in how we deliver on these programs and services with as little disruption as possible. To ensure that we are adapting in an informed manner, government departments have reviewed their legislation to understand which statutes have requirements that establish a limitation period, which statutes establish a requirement for a person or the government to do, obtain, or provide something within a specified period of time, which statutes require government to hold meetings or public meetings, which statutes include form and manner requirements, and then finally, which statutes have requirements pertaining to the payment of fees. On June 18th, 2020, Minister of Education and Lifelong Learning, Brad Trivers, received a letter from the Chair of the Standing Committee on Health and Social Development with 3 questions. 1, how did COVID-19 impact the operations of the department, and specifically through legislative barriers in this instance? 2, which acts fall under the department's area of responsibility? And 3, what acts should be amended to accommodate responding to the state of emergency, and in particular, which sections and why? So, Chair, now I will take a moment or a couple minutes to actually respond to those questions. And you guys have all been provided our written response, and that will articulate this point forward. So the first question, how did COVID-19 pandemic impact the operations of the Department of Education and Lifelong Learning? And by and large, the department has been able to continue to serve Islanders throughout the pandemic, even with reduced capacity and some operational constrictions in place. But specific to the legislative barriers we have faced, when looking at opportunities for early years centers to deliver childcare programming to more children with social distancing protocols in place, the department considered the use of public schools, due of course to their availability and because of the large space and footprint that they offered. Upon review of the Early Learning and Childcare Act, a license to operate an early years center is restricted to one premise. So that made it not feasible, or not possible rather, for us to make use of those school spaces. So the proposed bill, in question Bill 37, could have then allowed the department to obtain an order from Lieutenant Governor and Council to make the amendment during the state of emergency, which would then have made the schools available to those early year centers for the purposes of childcare. So fortunately, that was really the one significant barrier we did face. Of course, there were a couple other items, in more so in Regulation and Minister's Directive. But I will move on to question 2 and 3, which I am going to answer in tandem. So question 2, which acts fall under our department's areas of responsibility, and what acts should be amended to accommodate what sections and why? So in response to question 2 and 3, the Department of Education and Lifelong Learning is providing an overview of the statutes that it administers and a high-level commentary on the types of provisions that may need to be changed to accommodate in an emergency. Without advanced knowledge of the exact circumstances of the next COVID-19 wave, we do not know which statutes will need to be suspended or varied, and the policy answers that will successfully address those challenges. The proposed Bill 37 acknowledges this challenge as it seeks to temporarily address legislative issues as they arise. I would also like to note that my response shouldn't be taken as an indication that these amendments will be required. Rather, they are a highlight of the type of situations that we may face, and those barriers that are contained could potentially be contained within the department statutes. So we have 14 pieces of legislation under the Department of Education and Lifelong Learning. So I'll read through them, and then I will identify those particular areas where a possible amendment may be required, and they will fit those 5 criteria that I had named off earlier. So the Archives and Records Act, which was proclaimed in 2001. With this particular act, we have not identified the need for any potential amendments. The Autism Coordination Act, proclaimed in 2019, and again, with this one, we have not identified the need for any potential amendments. So the Early Learning and Childcare Act, which was went through Executive Council, the Legislative Assembly in 2010, wasn't actually proclaimed until 2017. But in this particular instance, we had that licensing issue that I addressed in the answer to the first question. And then we get into some time limitation issues. So there are time limitations pertaining to the review of the suspension or revocation of an operator or certificate holder's license. So a certificate holder is essentially those professionals who work in early years centers. And again, these particular time limitation periods, could be suspended or varied during the period of an emergency. Under the Education Act, which was proclaimed in 2016, so is a fairly modern piece of legislation, it didn't pose many issues for us because it was written, in such a manner that operationally we weren't constricted. So we were very fortunate. There are time limitations on hearing committee decisions on matters of student disciplines and suspension. Time limitations on the notification by education authorities for the termination or suspension of a teacher. Time limitations on the notice to refuse the issuance of a teacher's license. And again, these particular time period limitations could be suspended or varied during the period of an emergency. The Hairdressers Act, which was proclaimed in 2006, has limitation periods to appeal licensing suspensions, time limitations to terminate or impose a condition on a license holder, time limitations to renew licenses, requirements for annual meetings of the council, of which there are 6 required annually, so this may or may not be an issue. It's not so much an issue that they require in-person meetings, but they are required to have such a high volume of meetings that could pose a problem if they're doing them quarterly or a bit more frequently, because there are 6 a year. And then and these form and manner and time period limitations could be suspended or varied during the period of emergency. The Holland College Act, proclaimed in '88, have time limitations on annual and financial reporting requirements, which could be suspended or varied during the period of emergency. The Island Regulatory and Appeals Commission Board Act, and we've not identified the need for any potential amendments to that piece of legislation. The Maritime Provinces Higher Education Commission Act, which is a piece of legislation that was proclaimed in '88. There are requirements for annual meetings which could be suspended or varied during the period of emergency. The Private Schools Act, proclaimed in 2016, there are time limitations for appealing the refusal to register a school or suspend a school license. Time limitations on hearing appeals and issuing decisions on appeals pertaining to the refusal to register a license or the suspension of a license. There are monthly attendance reporting requirements that are to occur on prescribed dates. There are time limitations on issuing of suspensions and revocations of an operator's license. And again, all of these time-based limitations could be suspended or varied during the period of emergency. The Private Training Schools Act, which deals, of course, with post-secondary, there are time limitations to provide, and there are quite a few. So these are all time limitation based. I'll just spare repeating that over and over because I'll list them quickly. So to provide notice of refusal to issue a license to operate a school or approve an occupational training program. Again, limitations for the operator to prove insurance coverage, for the operator to advise on changes to occupational training programs, for the operator to issue a student a transcript, for the duration of a temporary instructor's permit, currently established at 90 days, reporting and responding to complaints, limitations on the suspension of an occupational training program relating to the appeal for the suspension and termination of a school license or occupational training program license, and time limitations on issuing appeal decisions. So we're proposing that these particular time period limitations, again, could be suspended or varied during the period of emergency. The Public Libraries Act, so proclaimed in '92, and with this particular piece of legislation, we have not identified any need for potential amendments. The Student Financial Assistance Act, there are time limitations to appeal the decision for a request for financial assistance, as well as for the communication of the appeal decision, prescribed times for notices deemed served when sent by mail. So when a notice is sent by mail, the Act says that it is deemed to be received after 5 days after it is posted. So that, of course, with the stoppage and slowing of Canada Post and some of the mail delivery mechanisms, that could be problematic. And these time period limitations could be suspended or varied during the period of emergency. The Teacher Superannuation Act, proclaimed in '88, prescribes timelines for the valuations of the superannuation fund, which, if missed, would impact the annual indexation increases, and these time period limitations could be suspended or varied during the period of emergency. And then, of course, finally, the University Act, and similar to the Hong College Act, there are time limitations on the annual and financial reporting requirements, which could be suspended or varied during the period of emergency. So although not listed in this list and not in your formal responses that are in front of you, we do, of course, also have the Island Regulatory and Appeals Commission that falls beneath the purview of the Department and the Minister of Education and Lifelong Learning. So they have 3 pieces of legislation under their authority: the Rental of Residential Property Act, the Water and Sewerage Act, and the Petroleum Products Act. So we have spoken with IRAC, and given the incredibly tight time constraints, they are actually in hearings all week, so they've not been able to provide any feedback to them, but we have asked them to look into what potential issues they could face with any potential limitations that are in their legislation. So they have agreed to provide us with a response to that by next week. So we'll provide that to the minister, who can then issue that in through the clerk. So sometime early next week, we should expect to have that from them.
I just might add,
Sure.
This committee needs to report back by June 30th.
Okay.
I believe. So anything that, yeah.
Sorry, Emily, when is June 30th? Next Tuesday, okay. Yeah. We'll connect with them. We told them we would do any follow-up necessary after this meeting, so we'll ask for that by Monday.
Perfect.
Okay, I knew there was a time period on that.
Thank you very much.
Great, thanks for the clarification. Okay. So these pieces of legislation may be housed, just something to note, may be housed in one department, but they are connected to many others in government, and IRAC is a prime example where they actually administer legislation for so many other departments: agriculture and land, fisheries and community. And another example would be any change to the Teacher Superannuation Act. There also could be potentially reflective changes required in the Civil Service Superannuation Act. So just something to point out. As articulated by my colleagues from Justice and Public Safety, if departments knew what legislation needed to be amended in advance of an emergency, they would have done so already. Bill 37, to amend the Emergency Measures Act, is intended to temporarily address those legislative issues that we have identified, but more importantly, those issues that we've not been able to identify. And it is important to note that it is not enough to identify a statute or provision of a statute that may need to accommodate government action. It is also necessary to conduct the proper research, consultation, and expert review to ensure the change is both necessary and appropriate. So just a quick comment: anytime the Department of Education undertakes changes to anything related to education, particularly the Education Act or even the Early Learning and Child Care Act, we consult with the education authorities and with the PEI Teachers Federation, or with the Early Years Centers and their association as well. So that's something that we get very good feedback from, and we consider a very important part of our process. So without advanced knowledge of the circumstances of circumstances our department and government will face in the next wave of COVID-19, it can be difficult to determine in advance what needs to change and identify the appropriate remedy to accommodate the emergency. So the emergency powers outlined in Bill 37 is not our first recourse, but of course measures of last result, and they are intended to support the experts who protect the health and safety of islanders, but also to ensure islanders can continue to access government programs and services with as little disruption or impact as possible. While it is true we have been able to make changes to allow the continued delivery of our services, we cannot fully know what the second wave will look like and how it will impact the Department of Education and Lifelong Learning. Thank you. That's all I have to say at this time.
Thank you very much. This is great. John, you're okay? Yep. You don't want to add anything to that? Perfect. Great. So I'll open it up to the members of the committee for questions at this time. So Peter Bevan Baker.
Thank you, Chair. Thank you so much. Hi, Erin. How are you? Nice to see you. Your face. Thank you for that really comprehensive speed read presentation. Good job. And I mean, there's an awful lot of stuff in here. But if I was to distill down where you see the pinch points or the areas that could be problematic, they are, and I think this is, although I haven't sat in on the other departmental presentations, they seem to fall into two distinct categories. One is time limitations, time frames that are prescribed in various statutes that would be problematic in an emergency, and the other is the form and manner, whether that's related to in-person meetings or public consultations and things like that. I think you mentioned that you had 5 criteria by which can you just go over them again?
Certainly.
Or maybe the other 3 are contained within those broader headings, but I just want to make sure that I'm not missing something.
So, I'm sorry, I think I overlooked one on the first page. So, requirements that establish a limitation period, so largely related to the court and court hearings. Statutes, establishing a requirement for a person or the government to obtain or provide something within a specified period of time. So those would be largely what we talked about. Statutes requiring government to hold a meeting or public meeting.
Right.
Those with form and manner requirements, and those with pertaining to the payment of fees.
Peter Bevan Baker.
Thanks, Chair. So that it was the last one that didn't seem to fall necessarily into those categories. So the payment and fees, and I don't remember you actually specifying that in any of the documents. So is there a particular statute that would be problematic?
We would have none applicable.
Okay, all right.
Peter Bevan Baker.
Thank you. I don't think I said this, but thank you for doing all the work. And I realize that this has come, for all of us, those who are sitting as members of the legislature and civil servants who are busy all the time, but particularly when the House is sitting, I know that the things get ramped up. So I want to thank you for taking the time to do that. We have heard from other departments, and although I haven't been present, I've watched some of the presentation online, who have said that it was actually, despite the workload required for this, has been a helpful exercise because they have been able to identify perhaps outdated statutes or areas that do require attention. Forgetting the immediate concerns related to a potential second wave, are there any statutes that you identified that really need to be updated regardless of that?
Yes, I think that is fair to say. The Public Library Act, but of which there are...
Excuse me, Erin.
I'm sorry. Thank you. Thank you for reminding me. The Public Libraries Act is in need of some modernization, but again, for that particular act, we have not identified the need for any potential amendments, but we have been looking at that one. And my apologies, just let me take a quick look through. Again, we're fortunate to have some fairly modern pieces of legislation, but nothing else at this time that would really require immediate attention.
Peter Bevan.
Thank you, Chair. So you started, Erin, by specifying the Early Learning and Childcare Act and a particular aspect of that was potentially causing issues, and that was related to the use of multiple premises or alternate premises, perhaps is a better way of putting that. So were we able to work around that through regulation, or was that something that is going to require a legislative change?
At this time, it won't require legislative change. The early years division or section of the department was able to work with the early years centers to address those changes without any legislative or regulatory requirements. It just took a little bit of extra time to get there. Also, the initial demand maybe that they expected on the childcare wasn't as high as anticipated. So that issue didn't actually ended up being necessary, or rather that amendment didn't end up being necessary.
Peter?
Thank you, Chair. This was a sort of common theme in government, that despite all of the challenges that COVID presented, and of course the first wave is particular because it was so unexpected and we'd never been placed in this sort of situation before, and presumably subsequent waves, if they do, or rather when they arrive, we will be in a much better place to deal with it. Clearly, the Education Department had some very serious, there were serious repercussions as a result of this. But from a legislative point of view, even that one that you just pointed out regarding the premises for childcare, but providing childcare, were there any other, and I realize you've gone through the Act here and there are potential areas where it's been a problem, but were there any other immediate areas where you thought, oh my gosh, this legislation prevents us from doing A, B, C, or D?
No, fortunately, there were not.
That's great. I'm great. Thanks, Chair.
Perfect. Anybody else at this time? Yeah, Brad Trivers?
Well, I just want to say thank you to you guys for the great work and doing it so quickly and coming in here, bringing your reports to hand out to people at the committee. Fantastic job, and I know that you really scoured our legislation, which is fairly modern, and there's not a huge impact legislative to the Department of Education Lifelong Learning, but I think it's important to have that on the table, and this is one of the departments where Bill 37 probably isn't going to impact us much. So just want to say that. Thank you.
Perfect, excellent. Everybody
Okay, great.
Thank you.
Yeah. Perfect. And at this time, it's good. We're starting to get a snapshot from every department, and your input was valuable. And I appreciate, again, as on behalf of the chairs, we're excited to be here doing this, but we also want to thank you for the work. I'm sure you had a lot of work this weekend. So at this time, what I'm doing with each section is that giving you an opportunity to pick 2 or 3 things that you'd want to recap in your presentation that would be your final notes if you want.
Sure. I don't want to steal all the time from John, so please feel free to speak up if you need to. But I think for me, the biggest thing, I don't mean to speak out of turn, is that I am the policy unit, so if there are issues that were to arise, it could be challenging to face that. So Bill 37 would allow for, would certainly help to allow for us to be nimble because we don't know what types of amendments would potentially be required. So it can be difficult for, and certainly not that there aren't wonderful other people to support me within the department and at the education authorities for that matter, but there's no way I can possibly catch all of these items in advance and not really know what is going to be happening in the second wave or for future emergencies for that sake. So I think that for me is probably the one key point that I have, and if John has anything to add, I'll put him on the spot.
I think the challenge is being prepared for, or trying to be prepared for what the eventual emergency might be. I think we're in the middle of COVID right now, and we've been able to, as a department, maneuver through that from a legislative perspective. I guess it's just the unknown of what you might encounter in the future, and not really knowing what that issue might be or what that impact may have on you from a operational or legislative perspective. I guess that's sort of the unknown, I guess, is trying to predict.
Yeah, that's what this exercise is great. Michelle Beaton?
Thank you, and again, thank you, because I know that this, going through each and every one of the acts would have been a task in itself. Just something that you mentioned, though, was you can't possibly capture everything, which is completely understandable. Did you, when you did the review, did you consider any areas that you would be nervous if the act was suspended, that something would not, that something in the act would not be complied with during that suspension?
To speak candidly, there are the Student Financial Assistance Act. For that one, for example, we do have another expert within the department who would know that act much better than I. So I did consult with her, and she had not identified any issues. But that would be something that I wouldn't confidently be able to say that item is completely sound, especially since there's so many financial and lending functions associated with that particular piece of legislation.
Okay.
Yeah.
Yeah, perfect. Yeah, just
I'm sorry.
Yeah,
I'm sorry.
no,
Thank you.
It's a habit.
Just want to make sure your words are captured.
Great, I understand, yeah.
Michelle Beaton?
No, I'm good, thank you.
Great.
Thank you.
Very much. So at this time, I'll just let the committee know that we will now break after our guests leave we'll reconvene at 1 o'clock. For our next presenters is scheduled for 1 o'clock. So if you have anything over the lunch break, we can be fluid with this committee. If the discussion's providing you any thought as committee members, please bring that forward, because we have a lot of work to do this week. But I'd like to thank our presenters. You did very well. And for the committee members, we'll see you back here at 1 o'clock.
Great. Thank you.
Thank you.
Cheers.